All right, Mr. Simone is here, so I think we can start admitting attendees and start the webinar.
Okay, hello and good afternoon, everyone. On behalf of EuroChem Malaysia, it is my pleasure to welcome all of you to today's session on AI Policy Frontiers, Comparative Insights on the EU-Malaysia Dichotomy and its impact on business and intellectual property. That's a bit of a mouthful. EuroChem Malaysia is proud to champion conversations that bridge policy and businesses, creating opportunities for innovation and collaboration. Today's agenda brings together experts from both the EU as well as Malaysia to discuss the implications of AI regulations on businesses and intellectual property. We'd also like to extend our heartfelt thanks to our partners, the Southeast Asia IP SME Help Desk, the EU Delegation to Malaysia, MDEC, as well as our bilateral chambers for supporting this event. Before we proceed, a few housekeeping notes. This session will be recorded for internal use and the recording will not be distributed. I do kindly ask that you participants ensure that your microphones are muted unless invited to speak during the Q&A sessions. And for questions during the Q&A, please use the chat function or raise your hand virtually and our moderator will address them. So to kick things off, it is my pleasure to now invite our EuroChem board member, Mr. Simone Macario, to deliver his opening remarks.
Thank you, Naila. Can you hear me well? Good afternoon, everyone, distinguished speakers, esteemed guests, and participants. It's an honor to welcome you today to this webinar about AI Policies Frontiers. My name is Simone Macario. I'm a board member of EuroChem. EuroChem Malaysia is proud to represent a robust network of over 1,600 European companies operating across diverse sectors in Malaysia, acting as a bridge between European businesses and Malaysian government stakeholders. We advocate for policies that enhance Malaysian competitiveness and strengthen its reputation as a leading destination for trade and investment. Today's session exemplifies our commitment, driven by members of our IPR sector committee, to address the evolving challenges and opportunity at the intersection of intellectual property, technology, policy, and business. Today's section is particularly meaningful to me. As an entrepreneur with over 15 years of global experience in artificial intelligence, I've seen how innovation transforms industry and how critical governments and ethics are to ensure its positive impact. AI regulation in Europe prioritizes trust and transparency, while Malaysia is creating a unique path that balances innovation with oversight. This dialogue between regions is essential for business navigating these frameworks. Before we begin, I want to thank our partners, the IP SME Help Desk, the MDEC for supporting this event. Collaboration is vital to advancing discussions like this, and your contribution are deeply appreciated. With that, I'm pleased to pass the floor to Najla to guide us through the session. And thank you for being here. And I hope you will find insightful and inspiring this session.
Thank you, Simone, for setting the stage with those insightful remarks. Now I'm delighted to hand over the session to our moderator, Mr. Phye, head of EuroChem's IPR sector committee, who will guide us through the rest of today's agenda. Phye, the floor is yours.
Thank you, Najla. Thank you, Simone, for your excellent introductory remarks on this exciting topic. Good afternoon, everyone. We have I was just calculating the amount of knowledge and depth of experience from our four speakers today. It's really heavy going, and I always want to thank them in advance for sparing their time to share with us. The sequence of our agenda is we will first have a sharing on the IP aspects of the Malaysian AI guidelines stroke regulations, the impact on IP in particular, intellectual property, and then followed by what could happen in the future as we see how this important frontier expands in the Malaysian context. And then followed by a very interesting panel discussion between two esteemed speakers, one from MDEC, which is the Malaysian driver, economic driver for how AI will shape Malaysia's future. And then we have a speaker from the EU delegation, who will then tell us the EU, albeit limited experience to date because it just emerged, but what's happening there. And then we can possibly learn across both boundaries in the regional boundaries. So that being the case, I will now introduce our first speaker, who is Encik Azrul Abdul Hamid, who will deal with the impact of AI regulations and guidelines on businesses in Malaysia from an IP perspective, opportunities and challenges. Azrul is a litigator with over 24 years of experience handling complex IP disputes. He specializes in a wide range of IP matters, including patents, trademarks, copyrights, trade secrets, and design rights. Azrul is also adept at handling tortious claims, debt recovery, and contract dispute. Beyond litigation, Azrul provides strategic advisory services to clients in various industries, including retail, tenancy, and hospitality. He has extensive experience in public policy and government engagement, particularly in combating piracy and counterfeiting. Recognized for his expertise, Azrul is a member of our Eurocham IP committee, an IP external expert of the Southeast Asia IP SME Help Desk, and a member of the Cyber Law Committee of the Malaysian Bar. He has been consistently ranked by Chambers partners for his IP practice. Over to you, Azrul.
Thank you. Thank you for the kind introduction. I will share the screen with my slides. All I have to do now is try to look for the button that says share. Okay, here's it. Okay. We've gone through the introduction. So I would like to just briefly introduce the SME IP SME Help Desk. The Southeast Asia IP SME Help Desk is an initiative of the European Commission, which provides free, confidential, business-focused advice to small and medium enterprises and intermediaries in the European Union and other countries of the Single Market Programme, SMP, that are Norway, Iceland, Liechtenstein, Ukraine, Albania, etc., relating to intellectual property rights in Southeast Asia. Firstly, through the inquiry helpline, you can send any IP questions related to Southeast Asia to the help desk and receive a reply within 3 working days. Secondly, we also have the help desk organizes monthly training workshops and live webinars, which are tailored to the needs of SMEs across Europe and Southeast Asia throughout the year. Please feel free to subscribe to our newsletter and to connect with the team on social media to keep yourself updated on the upcoming activities. The Help Desk website gives you access to a wide range of publications in terms of country fact sheets, industry-specific IP guides, or general IP guides on various IP topics. We have this for all the different countries in the region, like Malaysia, Singapore, Indonesia, etc. These guides can be easily found on the Help Desk website. Last but not least, the Help Desk also offers interactive learning tools, for example, e-learning modules, which are also available to be downloaded from our official website. If you're curious about the benefits of intellectual property or IP for your business, go ahead and schedule an online meeting with the IP business advisor of the Southeast Asia IP SME Help Desk to learn more about how to protect and enforce your intangible assets when doing business in Southeast Asia. The consultation is 100% free. of charge for EU SMEs and easy to book via the provided link on the slide. There's a on the side here, you can see book your slot here. Mr. Benoit is an IP advisor who is an expert in relation to IP in the region, and I think also outside the region of Southeast Asia. So we'll go on to my talk today. I'm going to talk about, in Malaysia, we have an AI guideline. We don't have any acts yet. And I will talk about how this AI guideline will have an effect or how it will enhance the business in Malaysia. So in terms of the regulatory landscape in Malaysia, the key body that is in task with AI matters is MOSTI, firstly, and also the MCMC. And MOSTI is the one that has come up with the AI guidelines in Malaysia quite recently. And within this, I will go through briefly the crux of this AI guideline. In essence, it encompasses a basis of how Malaysia is planning to go forward in including AI into the Malaysian landscape in terms of the regulations. The AI guidelines provides us with 7 core principles, which are transparency, accountability, fairness, data privacy and security, reliability, safety and control, inclusiveness, and how it should be for purposes of the pursuit of human benefit and happiness. When I was going through the guideline, I mean, obviously it is very Malaysia centric. It is our guideline is based on the Malaysian country principles or the Rukun Negara, and also it is the guideline relies very much on the Malaysian rule of law and also our federal constitution. So from the legislative landscape, they have come out with this guideline as a basis on how AI in Malaysia should be approached in Malaysia. So when it comes to the idea of transparency, the idea behind this is that the AI-like algorithms should be transparent to ensure that any capabilities of this AI software or machine can be explained both technically as a process and on any AI systems and related to the human decisions. So in essence, what this means is that the entity that provides us with the AI should be open on how this AI works. You know, we don't want the AI to be not accountable, as it were. And this is and comes to the next ethics guidelines of AI in Malaysia, and that is accountability. For any for our AI guideline, it has to the AI function has to be clearly accountable to the users. What this means is that the developers, the owners of AI models or the AI actors should be made responsible for what, I mean, in terms of legislation, perhaps in the future, in relation to what the AI produces to the users of the AI. And this also goes back to the idea of fairness, where the development of the AI must be designed to avoid any biasness or discrimination against the end users of the AI. What this means is that an AI system is usually produced by the maker of this AI when it is when there is an input of data into this AI. So the idea of fairness in this regard is how this data should be should not be biased. It should be fair to all the potential users of this AI, so that it can give an output of something that is fair to its end users. And the fourth principle that is encompassed in the AI guidelines in Malaysia is data privacy and security. An example of this is that an AI process or an AI system should have secure means to ensure that any data that is put into the AI system is safe, and that the user's private data would not be compromised. And in Malaysia, we have some amendments to the PDPA, which is the Private Data Protection Act in Malaysia, where it talks about how the use of data across the borders, and how the users and the AI model has to abide by the protection of these data in Malaysia as well. And the fifth guideline in relation to the AI guideline in Malaysia is that AI systems should be safe, and it is reliability, safety, and control. The AI system should be safe and secure and perform as intended, and it should resist being compromised by unauthorized parties. So in essence, safe from being hacked, etc. Because this is a very huge issue in Malaysia as well, because in Malaysia we are very concerned in relation to the protection of information and data in the cyber world. Recently, we had also amendments to the Cybersecurity Act, where it imposes certain offences and also penalties in relation to offences under the Cybersecurity Act. So an AI model or system should be safe and should be reliable from being attacked from this kind of dangers, as it were. And also, the sixth guideline is that there has to be an inclusiveness in relation to the AI model. It must be inclusive for all stakeholders to avoid unequal access to AI, as in the case of social class. I believe what this means is that AI should be accessible to everybody. It should not be restricted to just very few companies or individuals in Malaysia. It should be, in a way, something that is not elitist, as it were, right? And of course, the last one, the AI system has to be model around the idea that it is to be for the pursuit of human benefit and happiness. The idea behind this is that this AI system should respect human-centered values. I think this is perhaps particularly peculiar in Malaysia as well, because our laws are very value-centric in some ways. Like we have several laws that prevents incursion into Malaysian values, as it were. And also, this AI model should be produced for purposes of human benefit and for human society, to enhance the Malaysian quality of life and the increase of human happiness. So basically, that's the seven core principles of the AI guideline in Malaysia. So it is very, I would say, quite an substantial or sophisticated, in-depth kind of a guideline. Although it is general in its concept, it is something that is very peculiar, and it shows how Malaysia sees that the AI has to benefit the society in Malaysia. Or it should not be something that be left on its own and be allowed to transgress against the rights of Malaysians as well. Because, for example, we also have seen quite a lot of generative AI, I believe that's what they call it, where you can easily adopt or pretend to be a person, and this it has in a lot of ways damaged the reputation of an individual. Okay, so I will go to the next slide. Opportunities from the AI regulation in Malaysia. So in Malaysia, essentially if this is still a regulation in Malaysia, it is not entrenched in law yet, but it is a good start for companies to use as a way of looking at how it can, promote its business using these regulations in relation to AI in Malaysia. And companies that adhere to the Malaysian AI guidelines, is the purpose is so that it can build trust with the Malaysian consumers, the end users in Malaysia. And trust is the main issue. If you look through the guidelines that I've gone through previously, to be able to be safe, to be able to regularize itself so that it can benefit the population, and it has to be fair to all in Malaysia. It should not be an AI model that is meant to just promote a particular portion of society. And of course, this regulatory framework, it gives a clear path to businesses in Malaysia to see how it can promote innovation, and also how it can contribute to the AI business in Malaysia. Consumer confidence also is very promoted in that by abiding to the regulations in Malaysia, we want something that is fair and is not something that is scary, as it were. And of course, the key challenges in the regulatory landscape is in relation to the compliance cost. Would it cost more for businesses to implement an AI governance system? For example, with the amendment to the Private Data Protection Act, there is a provision that you also have to have a data officer. And this is, of course, cost to the business, is another headcount that you have to consider in your setup. And of course, in relation to IP rights, there is a whole landscape of IP rights that comes with these AI models. I will go to the IP rights later, but it opens up a new landscape to how we have to think about IP protection vis-a-vis the AI models in Malaysia. And of course, you have to one of the major consideration when it comes to the AI models in Malaysia is how you also deal with a lot of data, and how this data has to subscribe with the local legislation in Malaysia, which is the PDPA, the Private Data Protection Act. And there is the main body that deals with the AI guidelines in Malaysia is the Malaysian Science and Technology Ministry. And we can see, even like with the growth of AI, that we can see is been going quite substantially quick, in the past few years. It has grown from a baby, I think now it's now in its teenage years. It's going to be an adult soon. So there's a lot of regulatory updates that the Malaysian government would have to follow, to keep up with. And we would need experts in the area. We would need the legal entities the lawyers, and the regulators and the legislators to keep up to date with all these AI compliances that I would say we would eventually have to be engaged in the future. And of course, we have to always have public consultations, conferences, working groups, and also webinars such as this to always keep abreast in relation to the AI developments in Malaysia. So how does this affect your companies in Malaysia? You have to, with all new technologies, there are different ways of dealing with the technologies. you have to establish internal policies for data handling. You have to have more AI model transparency, and also you have to ensure your AI models are of a particular ethical standards, which in Malaysia appears to be something that goes back to the regulatory or the cultural difference, the particularities of Malaysia. And this AI integration should also incorporate ethical principles, like how Malaysia is also going on that particular route from the looks of it. And we can see this also been done in some MNCs as well. I got another 1.5 minutes, so I'm going to be quick. So how do you strengthen your IP protection strategies? As I've said, there's a gamut of rights that comes up with the new AI products or models. The main one, as always, I would say, is it's always going to be your source code. You can protect this by way of your copyright and your patents. Chris is probably going to talk more about the patent strategy when it comes to AI. You have to. It's not as straightforward as your traditional IP issues, because you have an entity that is somewhat capable of producing things as well. It has that capability, if not now, soon in the future. So you have to know who owns the rights, the data you put in, who owns that particular rights, does it infringe rights to other people? And also, of course, you have to be prepared. The company will have to be prepared to make sure that you do not infringe other people's rights. And when it comes to the PDPA, I think we can even have another session on this as well. In Malaysia, we have amendments to the PDPA Act to ensure that the data that is used by machines or AI models has to be in compliance, and this also includes cross-border data, and also how the user is aware of how the data is being used. So in Malaysia, you have to embrace this ethical AI practice that is provided by the MOSTI. Just in conclusion, in Malaysia, the landscape is evolving. I think it's going to be evolving very fast, and these guidelines are quite significant, and compliance is necessary. I think I've hit my 20 minutes.
Thanks, Azrul.
Yeah,
Yeah.
I think just on time.
Thanks, Azrul. Yeah, thanks for keeping to the time, but I think your content has been very informative and challenging.
Yeah.
I like your growth metaphor that AI in Malaysia is in its teenage time.
Yeah.
And I still remember when my kids were teenagers, we used to call it terrible teens. Yeah.
I sympathize with you as well.
Yeah.
My son is in his tweens.
Yeah. On that note, I would move on to the next speaker, Mr. Hemingway, to deal with this teenage tension and conflict between IP and AI, where one could be dominating the other or vice versa, or one is being defensive. And so this topic, future outlook, harmonizing AI and IP frameworks, will be what Chris will deal with. Chris is a seasoned IP expert, specializing in patent, trademarks, and design laws. He is uniquely qualified as both a UK and European patent attorney, enabling him to handle complex cases across diverse technical fields, including mechanical, software, medical devices, and chemical innovations. With extensive experience representing clients before major IP offices worldwide, Chris has a proven track record of success. He is actively involved in professional organizations such as, okay, here you have to follow us closely, SIPA, MIPA, AIPPI, and APAA, and has served on various committees, including representing Malaysia at the international level. Chris' expertise is recognized by industry peers, as evidenced by his inclusion in Who's Who Legal, now handled by Lexology, and his consistent ranking as an IP star by managing intellectual property. Over to you, Chris. Thank you.
Thanks, Keat. Yeah, so let me just see if I can share content here. Okay, you should be able to see my screen now. So yeah, I'm going to talk about a little bit more about the IP aspects of the the AI and where we are now and perhaps where we're going as well. So to start with, I'm just going to show you some statistics on IP, really focusing on the patents because that's where I think more of the developments have occurred recently. So if you go back 10 years to the European Patent Office, this is just a chart of all the AI patents that were filed from 2000 to 2014. And you can see it's relatively flat. There's a little bit of growth towards the end, but generally you had between 500 and 1,000 European patent applications per year. Now, if we skip forward to the last 10 years, so now we're looking at 2015 to 2023, you can see there's been exponential growth. There's a little bit of a dip in 2023 because of COVID, essentially because of the delays that occur with when patents are published. But now we're looking at more or less 10,000 patent applications, a tenfold increase in the last 10 years or so. And let's not forget that ChatGPT was only launched about 2 years ago. So even before that, you can see that there was a lot of interest in AI and a lot of patents were being filed in respect to the developing technologies. And it's quite often that patents are an indication of how technology is advancing. So AI is probably one of the major developing technologies right now, as you can see from these graphs. Now, if we look generally, just actually in the last year, it has slowed down a little bit, but there is one exception, which is if you see the last chart here, this is actually green AI. So things to do with waste management, energy storage, improving the performance of chemical processes and so on. So like before, the graph is relatively flat for the first 10 to 15 years or so, and then there's this acceleration. But actually, just in the last year, it's outperformed. There's been more green AI applications being filed than before, but also the proportion of green AI is increasing too. So although it's a relatively small part of AI overall, the green part seems to be developing faster than the rest. Now, just as a background, we as Marks and Clark, we're part of a larger group, and we file more European applications directed towards AI than anyone else, and we also have the highest grant rate as well. So if you do need help in this direction, we're well placed to be able to assist. So when we're talking about AI inventions, what I suppose we really ought to talk about what that comprises. So if you want to get a patent for an AI invention, the normal patentability criteria apply to start with. So that's novelty, inventive step, and industrial applicability. And by those, novelty is, for those who are not familiar, novelty means not published anywhere in the world before you submit the application. Inventive step is usually the harder one to try and work out, because you have to show that your invention is not obvious to a skilled person. So not just a simple development, there has to be something a bit clever about it. And industrial applicability just means you can use it in industry. So that's usually fairly straightforward. Where we sometimes find, or usually find, that AI inventions struggle to get patented is where it's considered to be a mathematical method or software as such, whatever that means. And there are certain exclusions to patentability in many countries, and these are two of them. You can't just patent a mathematical method by itself. If it's a piece of software which just runs on a computer without really doing anything physical or having any tangible effect, then it might not be patentable either. So, for example, a computer game probably isn't going to be patentable in many instances because it doesn't really have a technical, tangible effect. So the way we deal with that is to try and relate it to something physical. I've given you 2 examples just here. So if you just have a method for training a neural network, it might be excluded because you're focusing on the mathematical method. But if you then use that neural network to do something, in this case, you can use it to reduce the power consumption of a data center. Now you're saying that it's got a tangible physical effect, so it may well be patentable on that basis. So as long as, if you've got some kind of applied AI, as long as you can show that it has some kind of technical purpose, then it may also be allowed. So if you can't quite relate it to something physical, but you can show that it enhances something or decodes something or transform something or convert something, as in those examples at the bottom of the screen here, down here, then you may still be able to obtain a patent for the invention. So I'm going to briefly touch on some of the regulations as well, but I know some of the others are going to be talking about this. So I'm just going to highlight a few interesting things as we go along, and I'm not really going to talk too much about this. All I really wanted to show was the differences between the EU and the US to start with. So I think, as Azrul said, the EU's got a new act that's already coming into force now. It's mainly risk-based, and for things like that are high risk, you've got around 6 months to take them out. So these are things like the highest risk are going to be prohibited. The high risk ones need a lot of oversight, and then lower risk face lower regulation. For the US, there have been some concern raised by the administration in March, but of course things might have changed now, and they're more likely to be market-driven and innovation-centric policies with less oversight, with less restricted government. They're going to focus more on developing the inventions of AI and make it useful to people, rather than the oversight that the EU is focusing on. So if you look at the EU one, the unacceptable risks are the ones that are going to be, you've got 6 months to take them out. I think it expires around February next year. The high risk ones are going to be much more subject to oversight. And I've just got 1 or 2 things on the next slide here. These are the types of things that are prohibited. And really the one that caught my eye was the biometric identification at the end. So it's really to stop people being manipulated by AI. It's to stop people from being labeled or taking things which are based on personality and so on. The one that caught my eye actually was the biometric information, because when you think of films like Mission Impossible, they at one point they're looking for Tom Cruise in the airport on the basis of AI using the facial recognition. So I thought, well, is this going to be something that's going to be prohibited from some point in the future? But I think certain agencies like the police are exempted from this. So maybe this will still happen. Perhaps it can be part of the discussion later. We'll have a look later. Then you've got the higher risk systems, where you've got to have things like risk management systems and quality management systems and so on. But then when you compare that, like I said, I'm just going to whiz through this quickly. When you compare that with someone like the US, you can see here that there seems to be much less oversight. It's more about preventing some bias and having some user data, but really there doesn't seem to be a requirement at the moment to have specific implementations of systems in place like the EU does. And when we look at kind of the other things that have come out from the US, this isn't really law per se. This is more like the recommendations that have been made. And I think with Biden's executive order, it's talking about promoting innovation and ensuring national security, he's trying to implement some ethical standards and risk management practices. But then later on, with Donald Trump's administration come in, he wants to repeal the dangerous executive order that hinders AI innovation, supposedly. So this really seems to be going the other way. now in the US, where there's going to be less oversight and more about focusing on development of the AI systems themselves. Okay. I think Azrul's already covered the Malaysian guidelines. As far as I can tell, it seems to be somewhere in the middle. It's not as stringent as the EU. It's not as lacking in oversight, I think, that may be perceived from the US or what might be coming in the US. So although I was quite interested here that, there's going to be some accountability, how that works in practice is going to be quite interesting to watch, because, if something happens to someone as a result of AI, is it going to be the company that's going to be accountable, or, the person implementing the AI, or the AI developer? I don't really know what the answer to that is yet. So there's still some way to go in terms of the legislation, I think. And really, this was just to show that the end users will have some rights as well in Malaysia. I particularly was interested in the right to interact with a human instead of AI, because if you've ever been on AirAsia's website, you know how frustrating it can be to actually try and talk to someone instead of going through their chatbot. So eventually you can get someone, but does this still fall under this or not? I think maybe there are some improvements that are needed. Okay. Really, let's come back to how AI can assist with intellectual property. So we did some experiments in our company just to see what would happen when we use AI to do some things. So, for example, if you wanted to create an industrial design, so an industrial design is something that is aesthetic in nature, and you can register a design if it's new and has features of shape, configuration, pattern, or ornament applied to an article. So we asked our AI to create an environmentally friendly beverage can cooling sleeve, and you can see it's come up with a few different options depending on which program you use. So you've got a can with this green sleeve around the outside. You've got another one with a kind of corrugated pattern. I think this one, I can't remember the parameters. I think they asked it to create something that was a bit more colorful. So AI can be quite useful in creating images of something if you give it the right parameters. When we come to trademarks, we said, okay, so a trademark is something which is essentially a brand, and you can register a trademark if it's a graphical sign which can distinguish the goods and services of one person from another, as long as it's distinctive. In other words, not descriptive, and also not identical or confusingly similar to anyone else's trademark. So in this case, we asked the AI to generate a brand name for the cooling sleeves that I just showed you. So the first one was Eco Chill sleeve, but that's a bit descriptive because it's talking about a sleeve which is cold or chilling. The same for Green Cool wrap, because I think it was, it's green and it's wrapped around the can. Eco Freeze Guard was a bit more interesting because it might be distinctive enough, but one of the things you've got to be careful about with trademarks is that you're not deceptive as well. So if this doesn't keep it frozen or under 0 degrees, otherwise they may be accused of it being a deceptive brand, which is not going to be allowed. And then the last option was chill leaf sleeve. So although it's a sleeve, chill leaf is it's quite an unusual word. So we thought, okay, that might be distinctive enough to register as a trademark. So with both designs and trademarks, I think we can use AI or third parties can use AI to try and generate or help generate their new designs or trademarks. But what about patents and inventions? So when we come to patents, an invention is patentable if it's novel, has an inventive step, and is industrial applicable. So it's got to be something a bit different to what's already out there. Another key factor, though, is the inventor always has to be listed, and in fact, he's entitled to be listed. But he's not often the owner, because if you're an inventor and you work for a company, then quite often by default the rights are transmitted to the company. Or alternatively, they can be assigned to the company. So usually the inventor is listed on the patent, but they're not, or quite often they're not the owner, unless the inventor wants to be the owner specifically. So what we haven't been able to do until recently is work out if AI itself can be an inventor. So this guy called Stephen Thaler created this AI system called Davos. which was essentially a big AI computer. And he fed some stuff into it and said, okay, try and invent some things. And Dabus came up with this food container, which was constructed with fractal geometry in the walls, so that it would help with the grip, and it also helped with heating. And you see from this picture in the bottom left, you've got wall of container A, which connects with wall of container B. And because the fractal nature of the walls, see, this is very small bumps and crevices, they sort of fit into each other, and that helps with increase the friction between the two cans, or the two containers rather. Claim 1 is shown on the left, and the important bit is the fractal wall profile of the wall permits coupling by inter-engagement of a plurality of said containers. In other words, that when you put the two containers next to each other, the walls kind of, it increases the grip. So Stephen Tyler filed some patent applications and put Dabus down as the inventor. Even though he was the inventor of Dabus, he put Dabus as the inventor for the patent. And what happened next was quite interesting. So this was in 2019. So initially in Australia, for example, the Patent Office, Intellectual Property Office, rejected the AI because it couldn't be an inventor. But the federal court disagreed. So when he appealed to the court, a federal court disagreed initially and said, actually, no, that's not. There's nothing to prevent AI from being listed as an inventor. So I think this was the first case where it was allowed for AI or a computer program, and in other words, not a natural person, to be listed as an inventor. Unfortunately, a year later, the full federal court, so the higher court, reversed this and decided that the inventor must be a natural person after all. And then we look at some other countries. So the EPO also said you can't, Dabus can't be an inventor because it's just a machine. He appealed it, and the Board of Appeal still said the inventor must be a person with a legal capacity. I'm going to come back to this one in a minute, because what was interesting is they didn't specify natural person. The UK more or less said the same thing. They also rejected it as it was a machine, and therefore couldn't be an inventor. In 2020, he took it to court. 2020, the court upheld it, and again didn't allow it to go further with appeal. In the US, same situation. The Patent Office rejected it as the Dabus wasn't a natural person, and that appeal court affirmed that. Again, same in New Zealand. South Africa was a bit unusual, because they did say that Dabus could be the inventor and has actually granted the patent. So this is, I think, the only case which is currently in existence where Dabus has been allowed to be listed as the inventor. There has been some commentary on it, though, that they probably shouldn't have done for some other technicalities where Dabus needs to be a natural person, but they seem to have skipped over that. So the general conclusion at the moment, at least, is that if you want to list AI as a inventor, it's not usually going to be allowed. It nearly always must be a natural person, not a computer or software or whatever. Now, I said I'd come back to the EPO because I'm wondering what the future is going to hold. So I put in a few 1980s films and some AI characters from there. So if you remember war games in the 1980s, this was where a computer was doing some simulations, and it couldn't tell the difference between reality and simulation. So it almost started a nuclear war by simulating a Russian attack on the US, and the US was ready to attack, and then nothing happened. So the computer started to take over and said, oh, I think we ought to attack back after all. But instead of a simulation, it tried to do it in real life. And the way they got around that was one of the hackers taught the computer how to play noughts and crosses, tic-tac-toe. And the computer realized that you can never win. And when it realized that you could never win in that game, it also realized that it couldn't win nuclear war either, because of mutually assured destruction, and therefore stopped the nuclear war. So in that situation, you're probably thinking, well, that's not really someone that's capable of inventor. It's not really an independent thinker. It's really just a computer trying to run through some stuff with some analysis. Later on, we get to Short Circuit, where you have some military robots. One of them gets struck by lightning and suddenly gets self-awareness, and he calls himself Johnny Five. And there's a lot of questioning about, well, is he alive or not? And I think the key part to it is where he looks at an ink blot test and says, well, it's an ink blot. This is various, it's just various characteristics and components, but it also resembles a butterfly. And at that point, they think, okay, he has some imagination as well. He's not just a robot. He's self-aware. He's got an imagination. And then we move on to Star Trek with Lieutenant Commander Data, and he's not only self-aware and has some imagination, but he's also creative as well, and perhaps even has consciousness. There is an episode where they discuss, how do you define if someone is alive or just a machine? And I think that one of the things that comes up is, well, how do you measure consciousness? Now, I'm not suggesting any of these are likely to happen, but along the scale of things, we're probably not around the war game stage, maybe not even at that yet. And it's probably, I suspect it's only when we get to something like Johnny Five, where there's some imagination, some creativity, is when you can actually say, okay, now you've got something that is capable of having a legal personality, someone that, something that can think for itself, where you might be able to say, okay, now we have something where maybe they can be the inventor. But this is something that can be discussed at length later. It's probably a whole topic for another session. One more thing I just want to touch on before I finish, I'm a little bit over, is if you're allowed to use AI to create patterns. So one of the things that is important is that with novelty, the invention shouldn't be publicly disclosed. But if you use AI to write a patent application, you're putting the data into a big database, and potentially that database could become public. And also it's used to suggest to other people. So if you put in information, it can put that information back out to other people. So potentially that means it's prone to leakage of information and could inadvertently destroy the novelty of the application. So for that reason, we don't use AI to write patents. The other thing we sometimes have tried to use it for is to get legal advice, but more often than not, it gets it wrong. And I think we've all seen reports of AI hallucinating, but actually it's probably more accurate to say it's fabrication or just falsification. And when I have looked at legal matters, it nearly always says, please refer to a qualified professional. So it can be useful for perhaps the more basic questions, but generally I would be very cautious about asking legal questions to AI at the moment, because I don't think I would trust the answers. So if you do need any help, I'm going to stop there with a slide of the people in our group, and I'll pass it now back to Keat.
Thank you, Chris. I watched all those 3 movies when I was that age, and what frightened me more is the Terminator series of movies, of course.
I thought about putting that one in as well. I thought maybe I'll skip that one.
Yeah. Excuse me. Thanks, Chris, very much for giving us the insights into how IP and AI can harmonize, at least in the sense of whether you could protect your AI by using the current IP mechanisms or registrations. So, ladies and gentlemen, we now move to the 3rd segment of our sharing today, and that is this exciting panel discussion, which now comes into play or brings into play the comparative analysis between the EU position and the Malaysian position, and whether this might be 2 contrasting approaches to the AI topic. For this, from the EU side, we have Mr. Dennis Barach. Dennis Barach is a Minister, Councillor, Head of the Trade and Economic Section at the Delegation of the EU to Malaysia, based in KL since 1st September 2023. I think he's going to make KL his home. From 2011 to 2023, he worked for the European Commission's Director General for Trade, focusing initially on trade and sustainable development issues, notably with Japan and Korea, and then as coordinator for EU-India trade and investment relations, including the relaunch in 2022 of EU-India bilateral trade negotiations. From 2007 to 2011, Dennis was a counselor in the EU delegation to the United Nations in charge of development trade and macroeconomic issues. Dennis joined the European Commission in 1994, initially working on ICT and then development aid. Prior to this, he worked as a reporter for Reuters. Dennis holds a Diploma of Advanced European Studies from the College of Europe, Bruges. I'm not sure if I said it correctly, Bruges, Belgium, a master's degree in political sciences from the University of Strasbourg, France, and a master's degree in journalism from Northeastern University, Boston, USA. I also want to introduce the other panelists at this juncture, and that will be professional technologist Tengku Azhar. So this is the other Azrul in our speakers list. Yeah, I won't argue who is older and who is younger. Azrul has more than 20 years of experience in various industries, including energy, healthcare, transportation, banking, and township development. He is currently the director at Digital Industry Acceleration Division of MDEC, overlooking digital regulatory and sustainability. Besides that, he is a member of National AI Technical Working Group and a Prince 2 practitioner and a registered professional technologist by Malaysian Board of Technologies. I shared Tengku Azrul's CV because he was going to share first on the Malaysian position. So I'll hand over this time to Tengku Azrul. Thank you very much. Tengku, you have to unmute, yeah?
Yep, sorry. Thank you, Keat. Can I have my slide or I can share here? Oh, I can share here. Okay, before I go further, thank you, Eurocham, for getting me to this panel, and thank you everyone for attending. I am Tengku Azrul from MDEC. So we are the government agency under the purview of Ministry of Digital. So what we're doing is we're looking into tech and digital economy, from industry development, trade, and policy influencing. A quick one to this, we are looking into MD promoter activities such as AI, big data, XR, and creative media tech, advanced network, and whatnot. But let me just go straight to what I want to talk about today, is AI governance landscape in Malaysia. So the AI governance landscape in Malaysia started back then in 2020, where we have our Malaysia AI roadmap. That was a document developed by MUSTI. Then we have National 4IR policy by Ministry of Economy. Then we created National Blockchain and AI Committee. This is the outcome of Malaysia AI roadmap. In 2023, I think, so we had one called AI for AI initiative under Ministry of Economy and National AI Sandbox. And earlier speaker, Mr. Azrul, the other Azrul, mentioned about MCMC AI Code of Ethics for creative and multimedia industry. And we have a lot of investment coming into Malaysia. And the other one, the last one, is licensing for social media internet messaging services. This is from the KRI AI Impact and Governance Report that was released recently in August 2024. Then we are looking, sorry, view at the full screen. Then we have national level initiative where we're looking into Malaysia National AI Roadmap 2021-2025. So it is anchored by MUSTI, and the goal is to create a self-sustaining AI innovation ecosystem for development, leveraging into quadruple helix, guided by responsible AI principle. Then Azrul go on earlier mentioning about National guideline on AI governance and ethics that was launched in September 2024. I was one of the task force that was tasked to develop this. So again, it was developed by MOSTI, intended to establish a responsible AI practices to benefit AI developer, deployer, policymaker, and end user. We outlined the seven key responsible AI principle. I wouldn't go into those principles because it was touched earlier. But the crux of the matter is it encompasses the safety aspect, privacy, human right, which should be the priority when using or deploying AI technology. And currently, under National AI Office, under Ministry of Digital, we are developing a practical guide on AI governance and ethics. This will come out soon. So again, this is the 7 principle, the fairness, reliability, control, privacy, security, inclusiveness, pursuit of human benefits and happiness, accountability, and transparency. So if you look at how Malaysia tried to do that, we having one governance and ethics guideline, which is the umbrella document, but we're going to have a sectorial approach initiative where started with MCMC, which is a multimedia commission in Malaysia, that is targeting for creative and multimedia industry that encourage responsible use and innovation of AI in the sector. So represent the commitment to ethical, responsible, and equitable AI practice within the industry itself. And the target is the CNM industry player, which involve broadcasting, digital platform, and telecommunication. And currently, we are working together with Jabatan Digital Negara, Digital Department of Malaysia, National Digital Department, to promote innovation and to drive the usage of responsible AI for public sector. This is to support the aspiration of digital government, enhance public sector service through AI technology, and improve rakyat quality of life. And this, we would like to encourage participation of local AI developer. So for key element for AI adoption in public sector, we are looking into resources and capacity building, how adaptive the system is, monitoring and improvement, user engagement, ethics and accountability, implementation and compliance, standard, data management, security, and human oversight. So the 7 proposed AI ethical principle for public sector started off with data privacy and security, which, as Azrul mentioned earlier, is very critical in Malaysia to ensure the privacy and the security of data. We're looking into transparency, accountability, fairness, inclusiveness, reliability, and robustness and sustainability. So this 7 principle is derived from the AI governance and ethics document, because we wouldn't want to way from that, right? And the way forward for Malaysia is we're looking into responsible and sustainable AI adoption. We're thinking on how to do an AI sectorial adoption to promote awareness and focus demonstrating the benefit and the use of responsible AI adoption for the country. And we tailor the AI application to meet the unique needs and challenge opportunity within the specific sector. And we want to advocate AI governance implementation and adoption in various other sectors. And then the other prong of this is responsible AI advocacy. We need to continue interdisciplinary collaboration. Global collaboration is the most important here. We are looking into sharing our best practice, looking at resources and innovation across the border to promote the equitable AI development. And we are looking into delivering framework for policy, governance, and ethics to accelerate the growth and adoption of AI in Malaysia. I think that's it. Keat. Stop sharing. Quick one. Yeah.
Thank you. Thank you, Azrul. Yeah, it was a bit of a roller coaster, but I think we got your main points, at least on the public sector angle. Yeah. Over now to Dennis to share with us the EU albeit limited experience because of the timeline, but I think it's substantial enough. Over to you, Dennis.
Yes, thanks a lot. Thank you. And good afternoon, everybody. It's great to be with you today here on this call, and I really want to thank Eurochamp for the invitation. Unlike the other speakers, I'm not an expert. I'm not an AI specialist. I'm not a lawyer. But I certainly do take an interest in AI, and who doesn't these days? And I try to do my homework. But looking at these AI developments as an outsider, I would say that's been most striking for me and probably many of us is how much the speed of development of AI in the last 2 years has really taken us by surprise. And I think the unrolling of the chatbots based on generative AI in 2022 was really a revolution. And now you look around and AI is pretty much everywhere. Okay, it was already on social media before, but now you can see it in politics, in the office, in photos, in videos, a bit everywhere. And it's interesting because it's really opening up a lot of amazing opportunities. You can think about areas such as healthcare, transportation, manufacturing, but even environment monitoring, but also entertainment. But it also comes with a lot of I think concerns. And I'm not talking about doomsday scenarios such as the Terminator, but I mean concrete issues that we may all face in our daily lives. And that's, I think, where our EU approach comes into the picture. So I'll move to the next slide, please. Can I do that myself? Oh, it's amazing. No, I can't. Can you do that? I'm not sharing, so I'm not the one sharing the slide.
Is it not moving right now? I'm already at slide 3.
Okay, doesn't matter. I'll just continue. So I'll maybe introduce you to our AI strategy. So our aim on the EU side is really to draw the benefits of AI by supporting research and industrial capacity and promoting uptake by people and industry, including SMEs. But at the same time, we want to make sure that we ensure safety and the protection of fundamental rights. So in other words, we're really trying to strike the right balance. And for this purpose, we've elaborated, starting in 2018, an EU-wide AI strategy, which rests on 3 main components that I would like to briefly describe. The first one is an EU-wide policy framework, which covers our 27 member states, which was first drawn in 2018, based on a European Commission communication on AI. Communication is a policy document. But of course, given the speed of AI development, this policy framework needs to be updated and complemented at an unusually high pace. And I think the latest update we had was in January 2024 with another communication on innovation and trustworthy AI, which reflected a policy shift towards generative AI. The second component of the EU strategy is a strong investment and research leg, which is largely based on the coordinated action plan on AI, a tool which was launched in 2018, reviewed in 2021. It's coordinated in the sense that it combines resources from programs at EU level, such as our emblematic research program Horizon, but also from our member states. The idea being to have an EU-wide approach to investment and implementation. And this coordinated action plan covers some critical aspects of AI development, such as the development of the supercomputing infrastructure and associated data centers, which are necessary for the AI industry to strive, but also collaborations amongst companies across the EU. actions and investments in support of AI models and applications, as well as a specific package targeting AI startups and SMEs. So on the funding side, the contribution at EU level will be 4 billion euros between 2024 and 2027. The aim being to leverage also on the financial resources of our member states. The member states can also draw on our post-COVID recovery and resilience facility, where 144 billion euros was set aside for digital, which of course covers AI. And the third component is to have a sound EU regulatory framework at EU level. And that shouldn't come as a surprise because, as everybody knows, legislation is a key lever of EU action. There's already quite a lot of EU legislation of AI relevance, such as the CHIPS Act, the General Data Protection Directive, GDPR, or the Copyright Directive. There's also some technical safety legislation that needs to be revised and updated, such as the Machinery Regulation or the General Safety Directive. But of course, the centerpiece of our AI legislation is the EU AI Act, which is the first attempt in the world to regulate AI. Next slide, please. I think we're too fast. I think we should be at 3, the EU AI Act. Oh, what happened here? Did I? Okay, well, yes, thank you. So this AI Act is really part of the EU's effort to develop trustworthy AI in a balanced way. So on the one hand, the Act tries to reduce the administrative financial burden for businesses, notably SMEs, but on the other, it tries, and that's the main aim, to ensure that AI respects fundamental rights, safety, ethical principles, and it does so by addressing the risks which are associated with the very powerful AI models that we have now. So in terms of a timeline, the EU AI Act is a regulation, which means that it applies directly into the legislation of our member states from the moment of its entry into force, which was the 2nd of August 2024. However, the applicability will come in phases. And that was mentioned before by Chris. So the prohibitions will apply already on the 2nd of February 2025. The obligations for general purpose AI models and the related penalties will apply as of the 2nd of August 2025. And then the full application of the legislation will come in August 2026. And that's an act which, in terms of scope, applies to all AI systems, as well as general purpose AI models, which are placed on the EU market, whether they have been developed inside of the EU or outside of the EU. And fundamentally, the Act follows a risk-based approach and mandate certain requirements for AI systems, depending on the level of risk that they pose. And we can now go to the next slide with this little pyramid. And as has been mentioned already, there are 4 levels of risks, but I mean, I'll try to explain a little, give a little bit more details than before. So the lowest level is for minimal risk or no risk AI systems, and those are permitted with no restrictions. And that's, for instance, AI-enabled video games, or things like spam filters. And in fact, that covers most of the AI systems currently in use in the EU. The second level is for limited risk AI systems. This notion of limited risk is associated with lack of transparency in the use of AI. This typically applies to impersonation or AI-generated content. So if you're a user, you need to know that you're not interacting with a person, but with a chatbot. And by the same token, I mean, you need to know that a picture, video, and audio track has been machine generated. So these systems, limited risk systems, are permitted, but subject to transparency obligations such as information or watermarking. The third level refers to high-risk AI systems. So these are systems which are authorized, but subject to strict requirements and ex-ante conformity assessment. And that concerns systems which are related to critical infrastructure, such as transport, water, and energy, education and vocational training. For instance, you can think about evaluation of learning outcomes, employment, for instance, to evaluate candidates, but also law enforcement. And finally, the fourth level is unacceptable risks. That really concerns a limited set of harmful uses of AI, which are outright banned by the AI Act. And that includes social scoring, whether it's for public or private use, predictive profiling, for instance, to determine if a person is likely to commit certain crimes. There's biometric categorization, which is, for instance, based on race, political opinion, religious beliefs, or sexual orientation. There's emotion recognition, whether it's in the workplace or in education, and subliminal techniques, which are aimed at manipulating people, but also internet scraping for the collection of facial images to build a database. So that's for the 4 levels of risks. Next slide, please. Yeah, and I mean, at this stage, the focus is really on enforcement, and that's really going to be one of the most the key dimension of the AI Act in the coming months and years. So we created this EU AI office in February 2024, which will oversee the implementation of the AI Act. And one of the main aim, of course, is to ensure consistency in the application across the EU. So the AI office will work closely with relevant authorities in our 27 EU member states, as well as an EU AI board, which will be made up of member states representatives. So the responsibility for the application of the Act will be shared. So member states authorities will be responsible for the enforcement of rules for AI systems in cooperation with the AI office, but the AI office will be directly responsible for rules which concern general purpose AI systems. And so the EU AI office will develop tools, methodologies, and benchmarks for the evaluation of general purpose AI models. And they will work on the state-of-the-art course of practice. But it will also have a possibility to investigate possible infringements and impose fines, which will amount to up to 3% of companies' worldwide turnover, or 15 million euros, whichever is the highest. So this AI office will not work in isolation. It will obviously work with member states, I mentioned that, but it will also have the support of a scientific panel of independent experts, and also an advisory forum which will bring together all stakeholders, whether it's industry, academia, think tanks, civil society, and so on and so forth. So last slide. So I mean, that's really, for me, the general presentation of the EU AI strategy and the EU AI Act. Again, I'm not an expert, but I will try to to try to discuss particular aspects and respond to questions to the best of my ability. Thank you.
Thank you, Dennis. I beg to differ that you're not an expert. But then again, that could be coming down to artificial intelligence in the other sense of the word. Okay, so we have two very highly regarded panelists that have shared from their different perspectives, and of course we are here comparing EU and Malaysia. So I'll start it off with Dennis, knowing that there is an risk-based approach being used in EU, not very prominent in the Malaysian side. Can you elaborate whether this has actually shaped AI governance, and whether it is promoting or restricting, or how does it impact the businesses operating in Europe, if there's any data at the moment that sort of tells us how they are coping with it? Yeah.
Well, it's a bit early to say because it doesn't fly yet. But as I said, it's a risk-based approach and with incremental requirements depending on the level of risk. And I think from the point of view of the end user, the consumers, the benefits are pretty obvious. But now moving to the business side, I think there's some advantage in having this kind of regulation because you have clarity and predictability. You know what to expect. You know what rules you have to respect. And so you can tailor your compliance efforts based on the risk category, but you also know that the user will be confident in using your products. So that creates, I think, a level of confidence and safety for businesses as well as users. But of course, it's also clear that these requirements will create costs and relate to some complex procedures in some cases, particularly for SMEs. So yeah, that's why you have to look at you cannot really look at the AI Act in isolation. There's a broader context of the AI strategy, and as I said, there's this strong investment and research component. So yeah, I mean, you have to see that as a whole. Clearly, there are strong requirements for businesses. It's creating security for businesses, but it also creates a cost. And hopefully that will be counterbalanced by the measures we're implementing in terms of innovation and investment.
Thank you. Thank you, Dennis. Yes, as you rightly pointed out, perhaps the jury is still out while waiting for businesses to react. But I'm sure having to do a risk analysis of everything I do can be restrictive, which is why over in Malaysia, for Tunku Azrul to comment, where we are more allowing or liberalizing the use of AI to drive innovation and economic growth. So when you compare that with the risk-based approach, do you have any views on that, Tunku?
Thank you. I think, again, it's a bit too early for us to say that we're going to regulate. I think 2 days ago, our YB Gobin did spoke in the parliament to say that we might be using a certain approach, like guideline, code of ethics, rather than straight up legislative, straight up act, right? Because again, we are not the biggest economy out there for AI R&D, AI research and innovation, right? Hence why if you look at Malaysia National AI Roadmap, it is how Malaysia gonna harness the benefit coming out of AI for the next 5, 10, 15 years. We don't know. The roadmap aims to create a thriving and sustainable AI innovation ecosystem that make Malaysia high-tech and high-income nation. Again, it outlines several strategies like what Dennis mentioned earlier, you mentioned earlier. We're looking into how can we get more investment coming in. how we're going to establish a proper AI governance so that we're going to give a little bit of comfort to our investor. Again, with the investment coming in, the collaboration between the government and even the big giant of tech, right? We look into how we're going to advance the R&D, localize some of the technology like what we mentioned. I think it is top of the town, right? LLM. LLM is basically skewed to a certain segment of society. If it's coming from America, the value behind it mostly American. Coming out from Europe, value behind it is still very much European, right? The certain value is differ from one region to another, one segment of society to another. We took simple LLM to Malaysia. We have multiple dialect, multiple ethnicity, right? One value that is good for one particular segment of society might not be the same to the other. So those are the stuff that we need to look at, and at the same time we need to have a proper AI talent. The number that was needed by industry is huge. How we are galvanizing everyone from the primary school, secondary school, universities to ensure that we're going to be able to meet the requirement, meet the needs of the industry so that we can have that thriving ecosystem. And trust, we need to build the trust on our citizen using AI. It started off with AI for Rakyat. AI for Rakyat is AI for citizen. Because again, if you read the Malaysia National AI Roadmap and the AIGE, is the main theme is AI for all. You can't say AI is only for the likes of people living in KL, JB, and Penang. It has to cover everyone from Sabah, Sarawak, Kelantan, Perlis, and all. So when we look at AI governance and ethics, it aimed to promote responsible development and deployment of AI. We didn't say that with this governance and ethics, it has to be local made AI only. No. If you are deploying something from, let's say, Europe, if deploying something from the likes of Google, Microsoft, it has to have the responsible element to it, and the target stakeholder is not only for AI developer, it has to cover everyone. Hence why I think Azrul mentioned earlier, or even in my presentation earlier also, the two Azrul mentioned that AI developer, AI deployer, policymaker, and end user. So the initiative basically, we try to harmonize that with the likes of ASEAN, for example, how ASEAN view this and how we take that from ASEAN level to Malaysia level, and from Malaysia level, how can we go to sectorial? So certain industry, yes, I agree, it need to be regulated soon. Financial sector, for example. But the appetite of how we're going to regulate that is still out there in the world.
Yeah.
That's my take to it. Yeah.
Yeah. Yeah. Thank you. Thank you. Some parents now tell me 20 years ago, we used to send our kids to study computer science and do software development. Now they want to send their kids to study how to prompt, studying how to prompt AI programs, right? And it's the kind of studies we have now.
Yeah.
Yeah. Okay. Before we move into this, what Azrul, the other Azrul, and Chris had mentioned about perhaps a slight tussle between IP and AI. Before we go there, we just want to stop by EU and ask Dennis about data privacy, because we all totally respect the GDPR. At least me and my clients over here, whenever there's some European aspect of data privacy, we get into this issue about how do we comply. So Dennis, wondering if you have any views on the ethical AI aspect overlapping with quite strict data privacy rules and frameworks under the GDPR. Yeah, could you enlighten us if you can? Yeah.
Okay, that's complicated one. I think yeah, there's no immediate. Yeah, I'm not certain there's a direct link. I mean, clearly you're in a framework where you have to respect both regulations. There's the GDPR, there's the EU AI Act. You have to clearly respect the two. Now, it's clearly having an impact on businesses in the EU, but also outside. If you want to deliver, products or services in the EU, so the EU is based on, I mean, like Malaysia, obviously, but I mean we work on the basis of the rule of law. So yes, these rules have to be respected, and obviously businesses will have to bring their practices and they're in line with these requirements. That is clear. And we realize this may also have an impact beyond the EU border, and that's really related to the size of the EU market. So obviously, some companies will want to develop products and sell them in the EU. So obviously, they may have an interest in thinking about that already at the stage of development of their products. But we've clearly seen GDPR having an impact abroad, and companies trying to very often having the same disclaimers, the same obligations on their website. So I guess we're probably going to see a little bit of the same with the EU AI Act. Well, I mean, that's again not the intention. The intention is really make sure that within the EU, whether you're based in the EU or deliver services or products in the EU, you respect our legislation. Yeah, I don't know whether. We can't hear you.
So sorry. AI having a risk-based approach and an ethical input versus what is really clear law in the GDPR always means AI needs to adapt. But is it intrinsically able to adapt to the whole world of data privacy as well as IP protection? Maybe I'll pass over to Tengku if you have a comment on that, whether globally or Malaysian-wise. As you say, we are learning from seeing what's happening outside, but we ourselves may be facing various conflicts when we try to merge globally with what's happening.
I think we try to replicate what GDPR did, right, for the whole industry, where regulating how important basically the data is, right? So we have a new bill, the PDPA 2024, right? We look at how to align this act to a global standard, mainly EU GDPR. So it includes on data portability, mandatory data breach notification, and stricter penalty for non-compliance. Because in Malaysia, if data leak, people just what to do? So with the new act, the non-compliance going to be penalized even better lah. But it is signaling a robust approach on how we enhance personal data security and how the government look at that as one of the critical matter when we are doing stuff. So again, when we look from AI point of view, YBM Gobin did mention multiple times that Malaysia going to launch our own office, National AI Office soon, 12 December 2024. So that office will function as the centralized office to look at what the new threat coming in, what's the global best practices that Malaysia need to adopt. So I think, again, we are not that far behind, but there need a learning, especially coming from the developed country like developed region like EU, America, how we approach things. So on AI policy development and governance, it will be spearheaded by NAIO. NAIO will come in. NAIO is National AI Office. That's a short form that we've been referring to, right? On how to align the best practices and how to synergize cross-border stuff like that.
Yes, thank you. Yeah. So Dennis, moving from data to intellectual property, and as was shared by Chris and Azrul and Tengku as well about this tension between IP and AI. Do you have a view on how it's playing out in the EU scenario?
Look, I think we as I said, we already have some body of legislation, notably on copyright on IPR. We have this directive on copyrights in the digital single market, which I think already addresses some of the challenges posed by AI. So one of the key elements is that the general rule for works which are protected by copyright and which are used to train applications such as ChatGPT is that the developers should actually seek the right holders' consent, unless exceptions or limitations apply. And in this copyright directive, I think the text on data mining exception is the more relevant that applies to the training of AI models. So basically what it says is Article 4 of the directive says that it introduces an exception to text and data mining for any purposes, including the commercial ones. But at the same time, it gives right holders the option to opt out. So right holders have a possibility to say, well, we don't want our copyrighted materials, text, data, whatever, to be used for AI training purposes. There's another exception, which is scientific research, but there is no opt-out. So I think that's very much one of the key issues right now in terms of copyright protection in relation to AI development. But the practical implementation of the opt-out system is still work in progress. So different sectors are advancing at different speeds. So I think the European Commission is trying to see how to improve the implementation of the opt-out mechanism. So again, that's still work in progress. There are also some relevant provisions on copyright in the AI Act itself. And importantly, developers will need to make available a sufficiently detailed summary of the training data they have used for their general purposes AI models for the assessment of the models. But that too is work in progress. So the European EU AI Office is currently working on a code of practice to help AI developers to fulfill their obligations in this respect. So it doesn't mean they have to provide all the data, but I mean, they have to provide a summary or an overview of the kind of data they use to train their AI models. And so the idea is to develop a template so that they can provide this detailed summary. And so that's a code of practice, which is in development, and we should have it by the month of April. So yeah, so just to say that there are already quite a number of things. But again, right now, we have the two focus, which is on the one hand, the text and data mining for the training of AI, and the other one, the obligation to give some information on the data which has been used for the training.
Yes, thank you, Dennis. That always, as I've always been amazed by the depth and the detail by which the various commissions you work on such details, and there's a lot to learn from. It's just Malaysia kan Tengku is like got to be careful not to cut and paste. Tak boleh buat, here, but because the mind behind it is different, right? And obviously for us as IP lawyers, it used to be that just because I'm inspired by a work, it doesn't mean I'm copying the work, right? To be inspired is not the same. But what happens when it's a machine learning exercise in being inspired? Should there be a difference in copyright law? It's one of those difficult for us to manage. My last question to the both of you, because time is pushing on, is the future. Do you see anything? Do you see anything for us to watch out for, whether by way of caution, by way of hope, in the near future, in this whole area of AI and its predominance over IP and so on? Anything that you would like to share with the panel before we move into the general Q&A? Yeah.
I think let me start here. When we look at AI, basically it's the disruption of workforce, right? You mentioned earlier, by Keat, last time people sending the kids to go and learn computer science like me last time, 20 years back. But now we are talking about prompt engineer. It's not even a word 3 years back, right? So we need to ensure that whatever that is coming to us fast, we need to basically able to know how can we handle our workforce. AI is not something new. I've been learning about that in the universities 18, 20 years back, right? It's basically the evolution of technologies. So when we talk about ethical engineer, now we need to ensure that whatever that we've learned able to meet the requirement of the industry. And then we are talking about people losing job because of AI. It's not something that is clear or very easy for us to solve that, but basically I would like to coin it as job elevation. You need to elevate yourself. You need to be able to use whatever technology that is coming in. Now we're just talking about AI. We're not talking about super AI that the Big Four is talking about, right? How AI can be a sentient being and whatnot. Then come Terminator lah. So yeah, that's number one. Number two, it is about how we regulate things, because now we don't know what to regulate. We don't know to regulate the outcome of AI system, or to regulate the developer, or to regulate the end user. So we need to have a clear framework. What should be regulated? Hence, it's going to be easier for us to look at it differently. I like how Europe do it. They regulate using risk-based approach, right? So Canada is coming up with their own AI Act, where they regulate according to the risk-based sector. If your sector is high risk sector, it has to be regulated. The likes of medical, transportation, education, it has to be regulated, because you need to have some oversight to it. Coming from technologists, oversight is pretty much important. You can't let the big boys do whatever that they think it is right for them. So yes, we are from crawling to walking to brisk walking. Hopefully we can be as fast as what Europe do now. And the journey of EU AI Act is not 1 or 2 years. I've read about that. It is about close to 10 years now, right? When you start to have this in mind. So yes, that's the biggest challenge, not coming from technology, coming from what to regulate.
Thank you, Tengku. Would like to add on to that, Dennis, about what you see the future, what could transpire soon.
I frankly, I don't know. I think fundamentally, I think AI is clearly not a trivial technology. It's probably the most life-changing technology we've ever developed, and I think it's it's important to have essential safeguards. And I mean that just you cannot just, you know, for the sake of growth, just let it grow and without thinking about the consequences. I think, yeah, clearly, I mean, there are, you know, social, economic challenges, but I mean, staying to in the framework in which of our discussion, which is more regulatory, I think on our side, so we looked at through the AI Act at levels of risks related to usages and not specific technology. I think we try to be quite broad and comprehensive. So in terms of coverage of issues, in principle, I feel that what we've done should be relatively future-proof. So yeah, I think we will now be focusing on implementation, and clearly there will be some adaptations needed to the existing legal framework, but beyond the AI Act in other areas. So and clearly we'll have to keep on working on both the regulatory side, but also very much on the innovation and policy side to make sure that we keep on top of developments and that these developments benefit society as a whole. And I think from this point of view, I think the human-centered or people-centered approach that you see in Malaysia is in a way very similar to what we have in mind. I mean, the big difference being that we have decided to regulate.
Yeah, thank you, Dennis and Tengku. I think the key word being balance. As you balance all these interests, or they say juggling all of this in the air and hoping we get the right formula. Yeah, it will be work in progress for a long time. I'd like to bring us back, all of us, Azrul, as well as Chris, to just go through a couple of questions that have come up along the way, and just let us hear from the attendees. Something for Azrul. I think something you said triggered this question.
Which Azrul?
Yeah, Azrul up to Hamid. Yeah. Okay.
Slightly older one.
Slightly older. Okay, slightly older. For businesses in Malaysia, what first steps do we need to take to make sure our AI strategies align with both Malaysian and international IP frameworks?
I think like from what we've heard today, right, the principles are essentially similar when it comes to Malaysian AI guidelines or regulations, and you can look at the EU regulations. So we are still starting at a similar starting point. So in order to, the steps we need to take is still the same when it comes to AI and IP. You just have to be sure you know where you are in terms of your rights and where you are in terms of not infringing other people's rights. So it may be, but at the same time, I would also say that AI also brings with it a gamut of complexities when it comes to data, when it comes to usage, you know. So you go down the rabbit's hole sometimes when it comes to the use of AI. So for businesses, it's just business as usual. Take precautionary approaches, know what are your rights, and make sure you do not infringe other people's rights.
Understand? Yeah. I mean, for me too, like my own firm, I think one of the first steps a business, SME or otherwise, would have to frame an AI policy, right?
Yeah.
That the company will abide by, and of course taking into account all these considerations. Yeah. Over to Chris. This question of what do you see happening? This is the question we posed earlier to our panelists, Tengku, Azrul, and Dennis. The question sounds like this: like the previous toddler to teen analogy, AI has grown so much in the past couple of years. What are some trends in AI in IP that we should watch out for in the next couple of years?
Yeah, that's quite difficult to predict. I mean, what we're seeing at the moment is a bit of a surge in green AI. So things like waste management, energy storage, improving the performance of chemical processes. And I think we'll see more of that because of the focus on an increasing focus on green technology which is quite likely over the next few years. It's most useful for things like, interpreting big data. So changes in the weather, there's a lot of weather profiling where AI is used. So I think we'll see an increase in the proportion of green AI in particular. Anything to do with big data, though, as well, could come up, and existing processes as well for optimization. I think those are the things that we'll see more of in the near future.
Yeah. Just to add on to the green, so my firm practices healthcare law, and we recently hosted a healthcare professor, doctor, expert who is using AI. And it appears that AI in the medical scene seems to be taking a stronghold because it does improve diagnosis, it does improve treatment, being able to search through that. Yeah, so I thought you're right. I think green and maybe medical seems to be the two areas. Yeah. Over to our panelists, Tengku, Azrul, and Dennis. It's a more regional question, this one. So developing countries, of course, Malaysia being one of them, but it's just that, Malaysia is chairing ASEAN already, right? And I think our PM number 10 has said that he wants to help innovation in the ASEAN region, I think in one of his speeches that I heard and I read. So AI definitely must be one of them. So in your understanding of how it is, what are the similar issues, how do you see the region, for example, Vietnam or the ASEAN region, coping with this, since we already know the Malaysian experience, whether you have any insight as to what's happening elsewhere amongst our ASEAN neighbors?
Okay, I think I had a few opportunity to participate at regional level to speak about this as well. The ASEAN region, mostly we are wait and see, right? We are waiting for some shaker mover to start something. But again, for AI, it's not that that example. The example for AI, it is not that correct because everyone wanted to try to do something. Because again, like what Dennis mentioned, it is an innovation that changed our life. So rather than looking at the specific use cases, what should the developed country do this? What should Vietnam do that? Malaysia do that? It doesn't go into that discussion. It is about what's best for your country, what's best for your citizen, what's your pain point, and what's the use cases that might be suitable for you. Let's say if it's suitable in the US and Europe, might not be suitable to us, right? But one thing in common that everyone will share is how safe the AI is. So under Malaysia Chairmanship, we are looking into ASEAN AI Safety Network. So what we are trying to do is basically to share. This is based on the roadmap built ASEAN guideline on AI governance and ethics. So we are looking into how can we have AI safety network among ASEAN state member, right? So this is the platform that every country, Singapore, Malaysia, Brunei, Indonesia, Vietnam, Thailand, going to share. This is supposed to be the approach. So basically that's a discussion. Discussion has started. So Malaysia Chairmanship, we try to look at how can we have that that safety network started.
Yeah, thank you for that. It's very heartening to see when it's safety, it was a priority. To start that off first. Dennis, do you have any insight on the regional scene?
I don't have any insight into the ASEAN chairmanship, clearly. But I think there are some objective factors which are related to the level of development of various countries. You think in terms of infrastructure, data centers, the availability of a skilled workforce, all these factors, or the availability of funding, and it's clear that this will have an impact on the development, on the pace of development and take up of AI. That's obvious. At the same time, I think that potential benefits and risks ultimately are probably very similar across the world. So the regulatory challenges that we face are probably also comparable. So I think this notion of striking the right balance is probably important everywhere. But of course, we all have our specificities, our sensitivities, and there's no one size fits all. So you might think that the cursor might go into one direction rather than the other in different parts of the world. But I think ultimately this notion of having the right balance and making sure that we that people remain at the center is probably fundamental and something we should all share.
Yes, thank you, Dennis. So I would like to pause here and just say thank you once again on behalf of EuroChamp to all four of you for really contributing to this lively discussion and certainly enlightening one for me and for I'm sure all the attendees. I'd like to hand over now back to Najla and Sheikh the event. Yeah.
Thank you so much, Keat. But before we conclude, could I kindly ask that our speakers and also our moderator give us a quick smile for a group photo? Okay, 3, 2, 1. Okay, perfect. Once again, thank you so much to everyone for your active participation as well as your insightful contributions throughout today's session. A special gratitude and appreciation goes to our partners, our moderator, our esteemed speakers, as well as every one of our attendees today. We look forward to future opportunities to engage, especially on the topic of AI and IP in the future. Have a good evening, everyone.
Thank you. Bye-bye.
Thanks a lot.
Thank you, everyone.